Now I'm going to give the floor to Þórdís Ingadóttir, who is an associate professor at Reykjavik University, Faculty of Law. And previously she was a faculty member at the University of Iceland, as well as New York University. Her expertise is in international law and in particular international courts and tribunals, international institutional law, international criminal law, and international human rights law. And Þórdís is going to talk about the ICC, the International Criminal Court, and state sovereignty and current challenges. So you have the floor, please.
It's on already? Is here? Well, thank you. Thank you for the invitation, and great to be here in this wonderful house. It was not mentioned in the introduction. This is also a very famous house in the saga of Iceland. There was a famous trial here some few years ago, I guess, former Prime Minister of Iceland, but that's something we can talk about later. This is very challenging. I had a long talk with Greta yesterday. I come see as the diplomat. They're used to, 6 minutes or so in the Security Council, 5. We are from academia. We speak in blocks of 45 minutes. But I will try my best. And when I saw the theme of the panel I was invited to speak on, it was about the responsibility to protect, it's about sovereignty, it's about great powers. Well, it's about ICC, I thought. I mean, that's the saga of ICC, the whole theme running through. And I want to really also make an effort to put ICC in this box of responsibility to protect. That's a new concept, but ICC and international humanitarian law, which ICC builds up, it's a long, decades-old concept in a way. So that will be my attempt. Just as a background with respect to ICC and sovereignty, it's nothing new about progressive or new about sovereignty and ICC. It's why do I say this? It's a treaty. It's a treaty, the oldest concept of sovereignty and international law. You're not bound by anything unless you ratify it. That was the key concept when ICC was established in 2008. So we have to keep this in mind. There was a lot of talk to have this sub-organ of the Security Council, like the ad hoc tribunals for former Yugoslavia and Rwanda. That was not done. We decided to be very supportive of sovereignty and international law and consent of state, so it was a treaty. And also keep in mind what crimes are within the jurisdiction of the court. It's a very conservative list, but also it's the same crime as fall within the doctrine of responsibility to protect. It's genocide, war crimes, crimes against humanity, and now really lately on aggression. So these are not new crimes, and I think it's very important to flag here that these are crimes covered by the Geneva Convention from 1949 and the Genocide Convention from 1948. Also treaties that states have ratified. All states have ratified the Fourth Geneva Convention. Most of them have done so with the protocols. So these obligations are long there. So it's not ICC or nothing. These obligations are really also in other treaties. And also with respect to sovereignty, ICC, in my view, is very conservative. The court does not have universal jurisdiction, which was tried in the negotiation, really pushed by Germany and others. It only has jurisdiction with respect to state parties, either territory or nationality of the perpetrators. So it does not reflect jurisdiction as is currently in national law, where universal jurisdiction is recognized with respect to some of these crimes. Mm-hmm. So it's also very conservative in the sense it's the court of last resort. It's very different from the ad hoc criminal tribunals for Rwanda and Yugoslavia, which had the first take on the cake. They could jump into the national jurisdiction and take whatever case they wanted. ICC can only act if a state is unable or unwilling to do so. So the major success of ICC was to be if there were no cases. if the national states were doing all the work like they are obligated to according to the Geneva Convention and the Genocide Convention. So in that respect, it's very conservative. And again, in my view, there's a lot of talk, I'll come later to that, with respect to the ICC and the Security Council. Yes, there was a compromise made, but also a very powerful one. The Security Council was allowed to refer cases to ICC, even though the ICC is outside the UN family for the independence of the court. And so, was this something new? No. This had been done with the establishment of the Court for Rwanda, for the Yugoslav Tribunal, everything within, and recognized as a power of the Security Council within Chapter 7. And they had, not formally under Chapter 7, but they had, UN had established another tribunals for Lebanon, Sierra Leone, Cambodia, and so on. There were 8 criminal tribunals operating. So this was nothing new also with respect to the role of the Security Council and establishment and referral of cases. Yes, there is no head of state immunity before ICC. Is this something new? No. It is a principal doctrine before the ICTY and ICTR. We all know the case of Milosevic and Karadzic. We know Charles Taylor before the Sierra Leone tribunals and so on. So this is nothing new. This has been confirmed by the International Court of Justice. In the case Congo versus Belgium, in the arrest warrant case, there is no immunity of head of states before international criminal courts. This is not something that was created for the ICC. It's in the international law. So having this conservative background, because just to put it in a larger picture, what is the situation today? Well, is it a universal court, which is extremely important? Well, it has 124 states. It's a lot. It's missing 70 states, obviously 70 or 80 states, but it has a large block from all regions, the largest block coming from Africa, major proponents of the creation of that tribunal at the time. We have various states, surprisingly, Kenya is a member of the states, something people forget in the news in the last months. It's a state party to the court. It ratified the treaty. Of course, we have a big players outside the court. Well, outside and not outside. They're not parties, like the US and Russia, of course, India. But that does not tell the whole story, not at all. And I have no idea how many minutes. I have plenty, I know. But what is the major challenges? Well, we have a major operation going on. We should not forget that. Now we have 10 ad hoc tribunals just within this one building in The Hague. It's a new tribunal that just made it to the permanent premises, last month. So it's in the making, but they have 10 situations from all over the world. Just to refresh, they have Congo, they have Central African Republic, they have Uganda, Mali, Kenya, Ivory Coast, Georgia, Darfur in Sudan, Libya, Ukraine, and then they're looking into examination by the prosecutor in Ukraine, Iraq, Palestine, Afghanistan, Guinea, Colombia, Nigeria, and from this month, Burundi. So if I talk about challenges, I mean, it's separate challenge in each situation, obviously, and I think that's also a key thing to keep in mind. There's no one solution for everyone. Everything has to be tailor-made for each situation. But because there was in the program talk about the great powers, well, there's a lot of talk about the Security Council and the ICC, understandably. There was a great progress when Security Council at the time, in 2005, referred the situation of Darfur in Sudan to the court, something that was not expected at the time due to the position of the US at the time. And later came Libya. Well, if you talk about the most problematic, one of the most problematic cases before the court, exactly those two situations. And now, and there is no backup from the Security Council following the referral. The cases were referred with no backup, no money even. it was a very cheap solution for the Security Council, having spent billions of dollars on the ad hoc tribunals. They referred the cases with no money at all and no backup. And there is no cooperation from Sudan, who is not a state party to the court. The case was referred based on Chapter 7. The chambers have, I think, at least 11 times made a request to the Security Council to support them in arrest warrants and so on. And talking about the role of diplomacy, and I want to flag out the important role of small states. The one who made the difference at the Security Council were whom? The Costa Rica. They knew the procedures, they knew how to act on them, they know the game. At least there came some response in 2008 from the Security Council due to Costa Rica, but nothing since. I think it took some years later to have the reply from Security Council, we have received your communication, period. So that's the situation there, and I think it was right for the prosecutor last year to say simply, I have hibernated the investigation in Sudan until Security Council will cooperate. I think there was nothing else for her to do. Of course, but again, is this new that the Security Council is not cooperating? Are we completely dependent on it? Is ICC going to live or die because of the lack of Security Council cooperation? No. I could be reading from old notes from class on ICTY and ICTR. There was really problematic apprehending Milosevic, Karadzic, Mladic. Security Council was not doing anything to support. Who did all the work? I mean, who were the pressure? It was the EU, the World Bank. So major states, individual states, I mean, they were the states pulling things together. So that's also important to keep in mind. Of course, the other major drama at the court is the situation of Kenya, which is a state party to the court, the biggest opponent of the court in the last years. And of course, everything falling apart now, finally, just 2 weeks ago, when the proceedings have been terminated due to tampering of witnesses. So that's another big dilemma for the court, and how they have to regain their strength and organization to protect witnesses and so on. But my final point, yes, I think we keep focusing on the major states. There's a lot to talk about peace or justice, and I think we are way beyond that. The biggest success of the ICC is the implementation at the national level. Following the entry into force of the statute, states rushed to implement their own statute in national courts, national penal codes, and so on. Why? They had this duty from 1949. They have an obligation under the Geneva Convention to prosecute. They have the obligation under the Geneva Convention to apply universal jurisdiction. No, they wanted to be able to prosecute their own. So everyone rushing, even the Nordics now, just in the last few years, implementing major codes. So you have this network out there now. You have universal jurisdiction kicking on in every state. So even though the ICC will not arrest or prosecute those individuals, the states will do, in my view. So that would be my final note, and I look forward for the discussion.